and keeping track of things, there's a lot of laws that you need to keep track of. So one law that is very helpful for planning boards to be aware of for staff and for boards is knowing the input and the assistance that the regional planning commissions can have. Again, there was a lot of talk this morning about developments of regional impact. Those are under RSA 3654 discusses of DRI, and RSA 3656 and 57 speaks to the procedures for that. So if you're staff to the planning board and an application has been deemed one with the development of regional impact, those are the RSA sections that you need to go to follow that procedure. You may also want to check to make sure that your regulations do outline what constitutes or development of regional impact. RSA 36A deals with conservation commissions. Now, conservation commissions by law are not considered land use boards, but there are another board that the planning board and the municipality would cooperate with, would work on issues with. One topic that conservation commissions and planning boards work together with would be for the master plan, which would be for your natural resource inventory chapter or recreation chapter or outdoor recreation chapters. So to understand what other boards' role is when you're working with them, you can utilize what RSA 36A is to understand a little bit about the Conservation Commission. RSA 155E, again, the excavation regulations. That's something, again, that planning board, if you are the regulator, excavation regulations, and those are the RSAs that you need to be aware of. There's different postings for excavation applications that are required. There's a different appeal periods for excavation applications. So as staff and to keep up with your housekeeping, you need to be aware of the differences in notifications and appeal periods based on what type of application is in front of the planning board. Also, in addition to the RSAs that deal with land use, you also have to deal with the basic RSA 91A, which is the access to governmental records and meetings. That's the baseline for requirements for notice of your meetings, when minutes have to be done, and the advertising or the posting of those meetings. You'll also deal with planning board, depending on where you're located in the state. You may be working with RSA 483B, the Shoreland Water Quality Protection Act. Again, these are the RSAs that you should be familiar with as staff to the planning board as to what happens if those types of applications come in front of you. If there's a development on the shoreline, you need to be aware that there are RSAs that would apply to that application in addition to local regulations. And the most RSAs that you will use was RSA 672 through 679. Those are the planning and land use laws. So as we go to chapter 672, that's the general purposes of the planning and zoning regulations. It has definitions there for planning boards to be aware of. RSA 673 describes the establishment of land use boards, again, the appointment of boards, general provisions for the meetings, alternates. That's where you can find information for your rules of procedure. RSA 674 addresses the master plan, capital improvements, the zoning ordinance, manufactured housing. Again, these are the RSAs that you're going to work mostly with. So you need to be aware of what they describe and how they apply to the board. 674 is big because that is where your subdivision and site plan regulation authority would come from. The planning board is only given the authority to review subdivisions and site plans based on whether or not the legislative body has given them that authority to review and have approval procedures for site plans and subdivisions. You have 675 addresses the methods and procedures for enacting land use regulations. That's how many public hearings you're going to have. Again, we learned this morning that for zoning amendments and for any land use regulation amendment, you need to at least have one public hearing. And RSA 675 will discuss that. Chapter 676 is administrative and enforcement. This deals how the planning board and zoning board, other land use boards with the historic district commission, agricultural commission, all of those types of things, the penalties, the issuance of building permits, those are the enforcement procedures for your board that you should be aware of.
Stephanie, there's a question in the chat that pertains to adoption of zoning amendments.
Okay.
Which is that what are the statutes governing how changes to the zoning ordinance should be noticed to members of the town, so residents, and how often public hearings should be held on these matters? In other words, how do you notify the residents of changes to the zoning ordinance?
Okay. 675 addresses methods and procedures for enacting and for amending land use regulations. So amending your land use regulations, the requirements is similar to whether or not a planning board was doing a formal application, meaning 10 days in advance that type of notice. So in order to properly notice for zoning amendments, you've got to post whatever your regulations would say. You got to post at least in 2 public places. I believe one of those can be your municipality website if you have one, and posting in 2 public places. Depending on your regulations for what the subdivision says, what your noticing requirements are, some communities still have the notification in the newspaper, but that's the notice to the public. Putting it out on your website, putting it at town hall, posting it at the post office, posting it in the newspaper. It would be the same as if you're having a formal application for a planning board. But 676 deals also with 675 is the methods and procedures for land use regulations and for noticing.
There's also a question about, do town planning boards have 5 or 7 members with the same number of alternates?
Let me look up. I can get an answer to that later because I think 672 does talk about how many members there are. So let me let me check on the break for that, and I can get back to you on that. So I can cite the RSA. Okay, so speaking of meetings, so as a planning board, you're either going to have a public meeting or a public hearing, and which is it? And a lot of times, a public hearing or public meeting, they're used in substitution of each other, but sometimes we have to be really specific, and we have to keep them separate, because a public hearing is a meeting that is duly announced and advertised in advance, that is open to the public, and is called by town council, board, planning board, or commission of the town for the purpose of taking formal public comments, both in favor and in opposition to a proposed action, and to make a decision on that action. So again, when you're holding a public hearing, that is a formal hearing. It's a formal public hearing where you are taking action on something, whether that's a zoning amendment, proposed zoning amendment, whether that's a change to the subdivision regulations, or whether that's an application that's coming to be considered. All those are done at a public hearing. You need to be specific about public hearings and public meetings, because it's that notice to the public that is very important, that you have to keep straight as your staff to the planning board. A public meeting is an informal meeting or hearing or workshop of a municipal board, committee, or commission, or the governing body, which would be your selectmen or city council or town council. So that the public may attend to a public meeting, say, your community's having an old home day meeting. So that's a public meeting, because there's nothing formal in front of that board to make a decision on. But they may be making decisions as far as how many vendors do we have, or whatever type of situation that would be. But for the purposes of knowing how to notice for what that board is, you have to be clear about whether or not it's a public hearing or it's a public meeting. And when you're breaking into whether or not something is a hearing or something is a meeting, the RSA 91A, which again is the basis for notifications and for public access to governmental records, what the RSAs consider an advisory committee would be any committee, council, commission, or other like body whose primary purpose is to consider an issue or issues designated by the appointing authority. So that would be a planning board. Governmental records is any information created, accepted, or obtained on behalf of any public body. Governmental records include any written communication or other information, whether that's paper submitted, whether that's electronic via email or another physical form. That is what's considered a governmental record. So according to the definitions of a public agency, it means any agency, authority, department, or office of the state or any county, town, or municipal corporation or other political subdivision. So that's what a public agency is. All of these definitions are important to understand what the planning board falls under and what your notification requirements are, your disposition of records requirements are. So you need to make sure that you've got all of your bases covered, with RSA 91A being the kind of the baseline for meetings and for notifications, for minutes, and for notice to the public. But you have to make sure that you're meeting those definitions within 91A. So a public body, again, is any legislative body, governing body, board, commission, committee, agency, or authority of any county, town, municipal corporation, school district, school administrative unit, or thereof. There's an advisory committee. Again, a planning board advisory committee could be a master plan subcommittee, a CIP committee. All those types of things are considered public bodies, and the requirements of 91A apply. So we've done what is a public hearing, what is a public meeting, but what is a meeting by law? What's the definition? So a meeting by law is the convening of a quorum of the membership of that public body, which is, that committee. And when does a meeting take place? According to 91A, a meeting takes place whether you're in person and by telephone, electronic communication, yes, that means email, or any other manner such that all participating members are able to communicate with each other contemporaneously for the purpose of discussing or acting upon a matter or matters over which the public body has supervision, control, jurisdiction, or advisory power. Again, review these types of things with your town attorney as staff to the planning board or as the secretary to the planning board as an officer. You need to make sure that things are spelled out clearly in your rules of procedure as far as communicating via email. Okay. If your planning board members are talking about an application on email, you're having a meeting. So the best case scenario or the best, rule of thumb to do is just planning board members just should not be communicating via email. Staff can send stuff to the planning board. Probably using blind CC is probably the safest thing to do, but you should be reviewing these types of things with your town attorney and make sure that they're in your, the board has an understanding, whether you want to put it in your rules of procedure or it's just an understanding that communicating by email is just really not appropriate. And when what's not considered a meeting is if two planning board members run into each other at the supermarket. Okay, we understand that, small towns, people are going to know each other. Your kids go to school together, you're seen talking at a baseball game. That's fine. You can't get around that, but that is not a meeting, as a chance meeting, at a baseball game or at a grocery store or at a restaurant. That's not considered a meeting. Also, what is not considered a meeting is consultation with legal counsel. So again, if you want to bring in your municipal attorney to a planning board meeting to discuss, application that you have, work with your town attorney, but that is not considered a meeting with legal counsel. So make sure that you've got that procedure down and you understand how that should be noticed, how the minutes are supposed to work, all those types of things, the responsibility of staff or the secretary to the planning board to make sure if you're having this meeting with legal counsel, that it's legal. It's a legal meeting with your legal counsel so that you're doing it right and you're noticing it correctly. Another thing to be aware of when you're dealing with 91A is the circulation of draft documents. When finalized, are intended only to formalize decisions previously made at a meeting. Again, work with your municipal attorney and come up with a policy of how you're going to be circulating materials, whether that's minutes, whether that's notice of decision to the chair or the vice chair. But you've got to be careful. Again, make sure that you're not in violation of 91A and not have planning board members communicate.
There's a question here, Stephanie. Can a planning board member contact another planning board member via email one-on-one? So it's not a quorum, it's just two planning board members talking.
I mean, I guess you could. I would always err on the side of caution because, you know, I'm not really sure why one or two planning board members would be talking about something that's not, they wouldn't talk about in public. So, I mean, there's many different opinions out there regarding that. Myself, I'm of the school that it's really just not a good idea for planning board members, 1, 2, 3, even if it's not a quorum, to be talking via email. You're kind of inviting trouble. But again, talk to your town attorney. They're the ones that have to defend you and defend your regulations and stuff like that. So for your concrete answer, I would encourage you to talk to your town attorney. My, opinion on that is just don't do it. You're kind of just asking for trouble. Again, 91A, and there is going to be some overlap with 91A and some of the RSAs for planning board as far as noticing and for minutes and things like that. But 91A is the basis of what you have to comply with. So if you're complying with 91A, then you're pretty much okay. Otherwise, for meeting the requirements for minutes and notices of decision. So it's in 91A that also says minutes shall be promptly recorded and open to the public inspection not more than 5 business days after the meeting. Again, that's something that staff to the planning board in your housekeeping and keeping track of the planning board and keeping track of the planning board's records, you've got to make those minutes available to the public inspection not more than 5 business days after the meeting. And for when you're noticing a meeting, a notice of the time and place of such meeting, including a non-public session, shall be posted in 2 appropriate places, one of which may be the public body's website, your town website, if you have that, or shall be printed in a newspaper of general circulation in the city or town at least 24 hours in advance, excluding Sundays and holidays prior to such hearings. So it's pretty important, again, for you to know what type of meeting your board or commission is having and what the noticing requirements are for that. Because if you're having a meeting, a public meeting even, and someone forgot to post it, then you can't have that meeting. So it's really important that everyone make sure, planning board members, everyone who's staff or who's secretary for planning board members, you have to understand the noticing for the board meetings. And so the land use RSAs have their own noticing requirements. And so there is, again, as I said, there's some duplication with 91A and some of the RSAs for the land use boards. But these are some of the things that you need to be aware of for noticing for planning board meetings. So 672.2 is your definitions for abutters and kind of spells out what you're going to do in each situation. As far as with, say, a condominium association is an abutter. Well, the RSA says you do not have to notice every condominium unit owner. The RSA clearly says, in the case of an abutting property being under a condominium or other collective form of ownership, maybe a co-op, The term abutter means the officers of the collective or association as defined in the condominium law, which is 356B3. So again, if you're responsible for noticing the planning board meetings and you're the secretary or your staff to the planning board, you've got to understand the differences in notifications based on what the type of application is or what the abutters are and what constitutes an abutter. So all of these things you've got to be clear to make sure that you're noticing properly and correctly.
There's a question here. Sorry, Stephanie.
Sure.
Does a library newsletter constitute a public post?
I would say yes, but maybe that's something that you would want to, if that's something that, goes out to everyone in the town. 91A talks about, a newspaper of general circulation. Let's see, go back to that. What does it say? Shall be printed in a newspaper of general circulation in the city or town at least 24 hours. I mean, if the library newsletter only goes to specific people, then I would say no, that's not general circulation. But if the library newsletter is sent out like the grocery store, weekly shoppers, I would say yes, then that would count as something as a general circulation. But these are types of things, these little nuances for that is something that you should work out with your town attorney to make sure that using the library newsletter does meet the requirements, the minimum at least of 91A.
There's also a question here. Which statute states that it's the applicant and not staff that are responsible for the abutter list?
It's in your regulations where the applicant would say the what you require as a completed application.
Right,
That
but
the applicant.
It does say in the statute somewhere, doesn't it?
That
it's
yeah.
that it's the applicant responsible. I can't remember which statute it is.
I think it
so
is.
I think this person is saying there may be an impression that it's the staff's responsibility to do the abutter list. So I think this person may be asking, where does it give us the authority to say that it's the applicant's responsibility and not ours? So maybe that's another one we can check on.
Yep. Okay. Thank you. Good question. Okay. So, okay. So for purpose of receiving notification by a municipality of a planning board hearing, a local land use board hearing, in the case if an abutting property owner is a manufactured housing park, then as defined in RSA 205A1, the term abutter includes the manufactured housing park owner, the owner themselves, and the tenants who own manufactured housing which adjoins or is directly across the street or stream from the land under consideration by the local land use board. So again, these little nuances that are buried in the laws as for who you're supposed to notice and how you're supposed to notice them are very important. You may have condominium owners coming in saying, how come I wasn't noticed of this, this application going on? You can point to the law to say it's the municipality has done their job. They have noticed by law the condominium association. It's the association's responsibility to disperse how they see fit to the other condominium unit owners. So that's not a responsibility of the town. The town has made their responsibility, the applicant, the town has made their, the applicant through the town has met the responsibility by noticing the condominium association. You do not have to notice every condominium unit owner. Same thing again with the mobile home park, just to make sure that you're understanding the noticing for these different types of applications. Not everyone in the park is entitled by law to be noticed. And maybe there's an argument to say that it's a courtesy to notice every single owner or every single mobile home park, the lot. If the applicant is willing to pay for that, you certainly could do that. But these are the bare minimums what the law requires for those, those types of applications aren't very common, but when they do come in, it's important that you understand how to keep them, how to notice them. Again, more For enforcement and adoption procedures, the notice for the public hearing for the amendment of master plan, subdivision, site plan, we had that question before. 675 is for the noticing requirements and procedures for the zoning amendment process, as well as for the regulations. 675-6, again, is the process to amend or adopt the master plan, subdivision, site plan. Again, all of these RSAs, when it's zoning amendment time, when it's time to amend your regulations, you need to know as either staff or secretary for the board of which RSAs you're going to be using to make sure that you're noticing it correctly. And again, make sure that you understand that for any zoning amendment, for an application, for regulation amendments, you need to at least have one public hearing. Administrative and enforcement procedures. Again, this is where you can find your rules of procedure, what needs to be included in them, or how where they should be stored, what happens after you vote on them. Also in 676, it allows the board to have joint meetings with the ZBA. So again, staff needs to understand how those are operated, how those are noticed, who serves as the chair. It is worth it sometimes to the applicant and the municipality to hold joint hearings, but they're not necessary, but it can be helpful to the applicant and to the community to have joint hearings of the planning board and zoning board. That could be, for an example, if an applicant needs a special exception and then does a site plan, you can have a joint hearing. 676.3 again talks about the decisions and minutes, what your time frame is, and also something that I always I'm a proponent of is the third-party review clause, which I think that every planning board should be taking advantage of when it comes to any type of application that they need technical assistance on, whether that's professional engineering or surveying or an expert. I think that every planning board should be using third-party review. And again, spelled out in the RSA that if you're the staff to the planning board or the secretary for the planning board who's doing the organization, it's important to notice when you're going to utilize the third-party review. 676.4 goes down to, again, notification, and it's a little bit similar to 91A. But 676.4.1D2 says that for notification, holders of conservation, preservation, or agricultural preservation restrictions and the public shall be given notice as follows. And a abutter shall be identified on any plat submitted to the board. The application shall include the names and businesses and addresses of every engineer, architect, land surveyor, soil scientist, whose professional seal appears on any plat submitted to the board. So at this point, I mean, part and parcel to answer the question of, who should be submitting, abutter information or whatever, but that it's, the abutters need to be identified on the plat submitted to the board. So there's one contributing factor to who's responsible for abutter information, and that's that the applicant shall be, submitting that plan should be identified on the plan.
We have a question here, Stephanie. If a joint hearing can be requested by an applicant, when applicable to their application?
Yeah, a joint hearing can be requested by an applicant. Yep. Again, if someone has a special exception and a site plan going on at the same time, they can request it. Mm-hmm.
Thank you.
Sure. Okay, so speaking of special exceptions, one thing that in my experience in working at OPD and working in municipal regional assistance and my, working in the municipal world in New Hampshire, sometimes, again, we're going back to that somebody uses a special exception or a special use permit. They're very different. And sometimes we need to be very specific and keep things separate and different and understand that the ZBA has a lane and the planning board has a lane. And sometimes those lanes come together, that there's no doubt about it. But those lanes also, for the majority of the time, have to be kept separate. And one of the things as planning board staff that you have to understand and make sure that you're organizing your board with what type of application comes in front of you is the difference between a special exception and a special use permit, or a conditional use permit. But, to make it confusing, their names are even kind of alike. But a special exception is outlined in the zoning ordinance, and the RSAs say that for a special exception, it is something that is allowed in the zoning ordinance as a permitted use, but there's another level of review. So say, for example, in order to have a doggy daycare, you need a special exception, doggy daycare in a residential unit, a residential district. So doggy daycare is required, but that particular use, the municipality has said, well, we're going to require that you go through the special exception process, and that this application would fall to see if you can meet these criteria of a special exception. So while that may still need a site plan, which would go to the planning board, the ZBA has a specific lane and specific criteria that they are reviewing when an application comes in front of them. And that would be for a special exception, as outlined in the zoning ordinance. And also a variance is different, and the ZBA can attach conditions to a variance, but the planning board shouldn't be having anything to do with variances, unless it's a variance needed for a site plan, and they can condition a site plan based on obtaining a variance. But both boards have to stay in their lanes and know their lanes. So when you're working with a special use permit or a conditional use permit, it is allowed through the zoning ordinance, but it's also to allow some level of oversight on a specific land use to better ensure that use is properly designed and located on property, and the use does not create conflicts with for abutting properties. So an example of maybe a special use permit or a conditional use permit could be, in my experience, I've seen some that if you want to have a shared driveway, then you need this a special use. Or if you want to have a driveway that's going through wetlands, well, it's a special use permit because that specific property needs a little extra guidance. It needs a little extra review threshold through that. So that's where it becomes confusing, is that the authority, even though it's in the zoning ordinance for a special use permit or conditional use permit, which same thing, it's in the zoning ordinance, but the authority is given through the planning board. So that's why there is some confusion with it, with people, and boards think it's in the zoning ordinance, then the zoning board has a jurisdiction over it. Well, that may be true unless it's a special use permit or a conditional use permit. And any people that is aggrieved by the planning board decision for a special use permit or a conditional use permit, may appeal that to the Superior Court as provided in 677-15, or to the Housing Appeals Board. Special use permits, conditional use permits are also types of application that the Housing Appeals Board has authority to review. So now, as staff to the planning board, a little bit of some office management tips. We had some discussion this morning about, when people can drop off applications, and someone mentioned something this morning about 425 drop-offs. Yes, you don't have to allow that. When I was staff to a planning board, we did our deadlines and meeting schedules was posted like November, December for the following year. So you can have deadlines and say, okay, the third Wednesday of the month by noon is deadline day if you want to make it to this planning board meeting. You could certainly submit before a deadline if you want. I mean, that's an individual choice, but you certainly can dictate a deadline day and time, because a 4:30 drop off is not productive for anyone, for the applicant or for staff that's responsible to take those applications in. So talk about that with your board. Talk about that when you're in your regulations, with your meeting schedule for 2025. If you don't have that, talk about maybe adding that and make sure that you have deadlines. So when an application comes in, it's administratively intense for those of us who are aware of, deadline day for a planning board. So the best thing to do, I think, in my opinion, what I've done is that I've created spreadsheets for tracking applications, plus their escrow accounts. And it's very helpful for the board to look at year-end reports and for the annual report for the city or the town. But it's also really important for the board to understand what types of applications are coming in and how many that they have for their own workload and for their own regulations. And consider, creating a cover sheet for each application. This is really important, especially if you've got like part-time staff or whether it's a planning board member that's doing your application, your administration and your office management. That cover sheet should just have kind of the basics so that if I pick up a file and look at it, I can tell right away, oh, okay, it was submitted on May 11th. Okay, its first hearing is May 20th. You should have some type of cover sheet that is a quick snapshot of what stage that application is in. It's helpful for staff and for the public to keep track of the applications that way. Again, my little thing is that to not verify abutters for an applicant. The applicant gets the information from town hall. It should be where the tax bills are sent. But as a rule, it's not my job to verify for the applicant that these abutters are correct. The applicant has to submit the abutter information. Also, another little nuance, from my days of being a land use, administrator and secretary to a board, if boards are still accepting applications that are paper, and we all know that, the applications can get kind of big, and there's a lot of them, depending on your regulations. I mean, I worked for a municipality where we would get like 12 copies of an application to come in for TRC, for the planning board members. That's a lot. So the applicant should be the ones who are preparing their application and not relying on town staff to take their time to make copies for them. You're missing one copy. Hey, can you copy this for me? One sheet of paper, that's fine. But don't make the additional copies for the applicant. That's really not appropriate for the town to be doing that. It's a lot of resources for the town when that's the responsibility of the applicant, because that's what your regulations would say. If the regulations say you have to submit 12 copies of an application, then that's on the applicant to do. So it's deadline day. So if you're the secretary from the board or if you're staff on deadline day, that the first thing that you're going to do is just do a preliminary review of all submissions. Okay. You're not reviewing the application for its content. You're reviewing it for acceptance across the counter so that it can go in front of the planning board. And the planning board is the one to determine whether or not something meets the regulations. At deadline day, you're looking at an application coming across the counter to see if all the requirements of your checklist have been met. Is there checks and fees? Is there escrow? Is there waivers? Are they signed? Are they correct? Is the application signed? Do I have enough copies of the plan? All of those types of things, that's what you're checking on deadline day. You are not looking at content. That's when you would assign an application number. The best way to do that, to keep track of it, is tax map and lot number, because those would rarely change. If you get into street addresses for filing your applications, street addresses and numbers can change, and you're kind of setting yourself up for some confusing record keeping down the road. So tax map and lot numbers are pretty steadfast and true to remain the same. And add, your PB 2024-001. That's kind of just a basic way to keep track of your applications, keep track of knowing how many that you have. On deadline day, also gives a courtesy call to the chairperson. You can let them know that, hey, we've got 10 applications. Hey, we have no applications. Hey, we have 2, but to keep the chair in the loop as far as, what's coming up for the next meeting. And you're going to process all the fees for the escrow accounts, if that's what's required from your regulations. Escrow accounts have to be kept separate. Each application should have their own escrow account. If you've got a 20-lot subdivision, you've got a Walmart, you've got a Dunkin' Donuts, all those applications, all those escrow funds, they need to be kept separate. And you can also start working on the public notice and the abutter notice on your deadline day, just because you're starting to, get into that. You're processing the applications. It's also a good time to get your notice for the abutters and for the public notice done. And so it's getting closer to the meeting. It is 7 days before, a week or so before you could start preparing the packets or finalizing the packets for the planning board, circulating them to the planning board at least a week in advance. is a pretty good rule of thumb, I think. I understand sometimes, you know, you get busy and packets go out late a day or two. Just keep in touch with the planning board. Let them know, hey, you've got 5 applications, you know, packets are going to be delivered such and such time. It's important that the planning board get their information as far in advance of the meeting. That way they can do their homework, and you can stress to them that they need to do their homework from the planning board packets. So make sure that you're giving them enough time to do their homework. You can, you know, preparing minutes and templates for the planning board. Again, it makes it easier if you're staff and you're taking the minutes, if that you've already got your template set up, you know, for the minutes and for the notices of decision, where at least you've got the name and the application and all of that in that. It's a little bit easier for staff, especially part-time, or if it's the board member is the one who's doing this, the administration for that. It's just helpful, and it's kind of a time saver. And you can review the agenda with the chair. Remember, the public hearing has already gone out 10 days in advance, right? You already know that. The agenda, that can be, you know, tweaked, but that only needs to be posted 24 hours in advance minimum, as we know. But you can review the agenda with the chair if there's anything new or any new board business or something like that you want to talk about. And the day of the meeting, make sure that you're confirming you've got a quorum. You can reach out to the applicants to make sure that they're still planning on attending. Some days, the day of the meeting is one of the busiest days, you know, in the office, because, you know, there's a lot of last minute changes. You know, Murphy's Law usually kicks in, right, the day of a meeting. So just be prepared for that. And you don't necessarily have to contact each applicant and each agent, and are you coming to the meeting? But if there's a question, or if you haven't heard from an applicant, it would be worthwhile to check on that, you know, to see if they're still attending. And then make sure you're talking to the chair regarding any changes or updates to the agenda based on whether or not applicants are coming or not. And so after the meeting, you know, the cleanup begins, and the clock starts for when the minutes and notices of decision have to be done. So 5 days to complete minutes and notice of decision. You should update all your tracking sheets if something was approved, if something was continued, if something was denied, something was withdrawn, and just make sure those cover sheets are updated. That way, you know, people can quickly figure out what's going on with an application if you're not there. It's especially helpful for part-time staff, or if a secretary from the planning board is the one who's keeping the board organized. That they understand from looking at the tracking sheets, what's the status of the application. You should, issuing the notice of decisions and working with your chair on what the conditions of approval are. You should be taking those from the minutes and put them right into your template for your notice of decision, as well as your findings of fact. And, you know, it's a responsibility to kind of work with the applicant as well. You know, we have a duty, as Steve spoke about this morning, and Ben had discussed as well, where there's a duty from the municipal, you know, employees or staff to the planning board to work with the applicant. You know, we're to get them through the process so they understand what's expected of them, what comes next, and that comes from the staff or the planning board member acting as staff. So working with the applicants and with the chair if necessary, so they understand what the next process is, what the next step in the process after approval. If that's, you know, getting in more, you know, escrow funds, if that's submitting final plans, if that's submitting a permit from the state that they're waiting on, all those types of things, the staff could be working with the applicant after an approval. Also work on updating your escrow accounts as well. And also, after the meeting, if something was approved at that meeting, again, working with the applicant on the conditions of approval. And Ben spoke about conditions precedent and conditions subsequent. You know, and again, for conditions precedent are conditions that are required to be met before a building permit can be issued. So that would be final plans, that would be, you know, the state permit, that would be escrow funds. All those things are required before finalization can take place. So it's important to make sure the applicant knows what's next so that they can move through the approval process at the final end of it. So once you've got your final plan signed, after you've submitted and met all your conditions, precedent, excuse me, then you can move to the conditions subsequent, which are conditions that run with the property, that run with the operation. So you've just approved a Dunkin' Donuts. Their drive-through is supposed to be only open until 9 o'clock at night. That's a condition subsequent. So if there's that way you can track if there's violations, if they're open at 10:30 at night, if they're open until 11. That's condition subsequent, hours of operation. Sometimes lighting, I've seen lighting come up as, neighbors, don't want, parking lot lights on past 10 p.m. Those are types of things that are condition subsequent. So as staff to the planning board, you need to understand the differences in those conditions and work with the applicant to make sure that they're fulfilled. And I've used this slide before if you've attended any of my my trainings before, where as a planning board member, you're going to maybe hear some, what I call the alphabet soup of planneries. You may hear banana, build absolutely nothing anywhere near anything from your community. Cavemen are citizens against virtually everything. A designosaur, a designer with an enormous impact. A dude, a Goomba, a NIMBY, a PITBY, or a YIMBY. So all of those terms you may hear in your role as a planning board member, and just to make sure that you're familiar with them. So this is kind of winding down. I'll be glad to start answering any questions. I just wanted to make sure that you guys are aware of the resources, New Hampshire Municipal Association, the New Hampshire Regional Planning Commissions. Again, if you need help with planning issues, if you need help with site plan reg renewal, if you need help with your rules of procedure, reach out to your RPC, and they're also there to help. And they can do circuit rider planning as well. They can help out with when they're required by law to be involved in the DRI process. So just be aware of the regional planning commissions. They're a great resource for municipalities. And we also have the Office of Planning and Development's Planning and Zoning Board handbooks. Those are links to those. OPD updates them every year, and they recent court cases, and as well as we've been hearing from today, is to take the tests that for the planning board and the zoning board. We do not share email addresses, but in order to take those tests to get a certificate, you do have to submit your email address. So, but we do not. The OPD does not share those emails. And the tests are from the planning board and the zoning board handbook. So it's kind of, there really isn't any punches to pull. It's from the handbooks themselves. And again, thank you for your time. This is, again, the additional information with the OPD's website. I'm sure you're all familiar with it by now, where you can find, and Heather talked about this morning, you can find additional webinars and previous conferences. And again, there's an online survey there that they've asked people to, take a few minutes to take part in that. So we could, the office can see how we're doing and see if there's any topics that you would like to be at future OPD webinars or at conference.
So we do have some questions, Stephanie, if you will take some.
Sure, absolutely.
Here's one that I think is very important. My town has only a part-time staff member. Should I look into hiring a consultant to review every complicated case, such as a special exception request? And I say I feel strongly about it because I would definitely encourage towns to have consultants review engineering, consultant engineers review their applications for sure. And the applicant should be paying for fees for those consultations as well.
Absolutely. Yep. I am a huge fan of third-party review, and that's exactly what they're there for. It's for the benefit of the town. I'm trying to find the slide. Where is it? Right here. Third-party review, 676 for B. Yes, absolutely. Absolutely. Planning boards should be utilizing third-party review. The applicant pays for it. It is beneficial because it's not the fox guard in the hen house, right? And it doesn't have to be a 40-lot subdivision, or it doesn't have to be, a Walmart. Even a small subdivision, say involves a road, say there's drainage issues or there's wetlands issues. Your planning board members are expected to do a lot, but you're not expected to know everything about every discipline, right? So it's important for someone to be acting on behalf of the town to address those drainage, steep slopes. What does this mean? What about a road? All those types of things, especially when it could be a complicated case, but even for a special exception type case, absolutely utilize third-party review. Unequivocally beneficial for the municipality.
Thanks. So there earlier up were a bunch more questions about notification. I think I'll try to narrow it down here to many of them got answered. I will also say that there have been a lot of questions here that Steve, thank you, Steve Buckley, has answered for us.
Oh, thanks, Steve.
Very technically and succinctly. But this was a question about posting written notices at the town library, the local post office, and the town hall, as well as on the town website instead of the local newspaper. And I would say that, yeah, that's what I have done in the past is not the post office, but the library, the town hall, and the website is what we've done.
Yep. And absolutely. And I think, forgive my ignorance, but and maybe Steve knows, or maybe Ben knows, that I think they may have tweaked that RSA as far as the notification board, because normally I think the RSA definitely says whatever your subdivision regulations say. So that's kind of why I mentioned it depends on what your regulations say as far as where you're posting it and whether that library newsletter is enough. But if your subdivision regulations say in the newspaper, then you need to follow what your regulations say. But those are the types of things that, working out with your town attorney, checking in your regulations. I always did town hall, before websites were huge for noticing. It was town hall and post office were the two public places that I would post things. And of course, with the newspaper.
There was actually a follow-up on that library newsletter question that said, what if you need a subscription to get the library newsletter? Can that still be counted as a public posting? That was kind of an interesting question, I thought, because newspapers are subscription, right? You need a subscription to get the newspaper.
Yeah.
But yet newspaper is considered much more general. Like you said, it typically goes out, or used to go out to everyone, whereas a library newsletter probably doesn't go out to everyone. Certainly not if you need a subscription to it.
Right. That's a good point. Right. So I would work on, getting the final answer from your town attorney. But it appears as though with what, Heather and I were just talking about, that a library newsletter, I guess it could be considered a newspaper of general circulation because you do have to have a subscription for newspapers as well. So, it's a good thing to discuss with your town attorney for clarification. But yeah, I could see how that would be used in both ways.
And Steve did just now post a good response to that as well, citing RSA 2131-2 defines newspaper of general circulation. And there's a long posting there that I'll let people read themselves.
Oh, okay, good. Thanks, Steve.
And let's see, there's another question here. Sorry, a whole bunch of questions just got posted.
That's okay.
Someone says, I haven't heard about the test. Why should I take the test? What are the benefits? I think that's a great question.
What are the benefits of taking the test? Well, OPD was required by law. The legislators thought it was a good idea for planning board members and zoning board members to take tests. And OPD was mandated to create this test system. So it's a good way to check yourself. It's a good way to see how much knowledge you have as a planning board member. You can get them with a certificate that says you've passed, or you don't have to take it with you passed. But there's always something to be learned. And I think it's beneficial for a planning board member to take a test and if you're not, to learn more about what you're responsible for, to learn more about what's available for you, and to test your basic knowledge as how you're doing as a planning board member, because it does affect your decisions. If you're not aware that third-party review is made available to you and it's paid for by the applicant, if you didn't know that, then you're missing out on some opportunities for the applicant and for the town to someone to work on your behalf. So that's why I would take the test.
I think that's a
Power in
great
education.
answer. That's a great answer, Stephanie, because I went on there and I took the test and it was a little bit humbling because it's a really great test. It's just some random obscure things. And I was like, oh no, I don't know the answer to these. So
Yeah.
I would go take a look at it just so you can be aware of some things that you may not realize are things that are important to know.
Yeah, absolutely.
It's almost just another educational opportunity for you to realize what types of things can be important.
Right, right. And as a matter of fact, I mean, I know it's zoning board, but the zoning board, I don't know the RSA off the top of my head. Maybe Steve will find it by the time that I
Yeah.
get done. But ZBAs also have the ability to use a third party review. So if you have a special exception coming to the zoning board of adjustment, and it's pretty technical for whatever the use is, the ZBA has the same exact ability as the planning board to get that third party review. If you don't have third-party review, can't stress enough. It's one of my favorite things, that and TRC. I love the TRC. But do third-party review. And as the planning boards, of course, applicants aren't going to really be that much in favor for it because they have to pay for it. And that's part of the real perk of a third-party review, is that it's someone working on behalf of the town, that the town does not have to pay for that. So your options are not having a third party review come in for, when a subdivision with a road is coming in, you're going to take the applicant's engineers. It's not to be disrespectful to any engineer or surveyor. It's just that it's just going to take that one time for a municipality to get burned by a developer that's cutting corners or was incomplete or mistakes were made. And then the town is stuck with that road. The developer is long gone. But the town and the people who live on that road are stuck with that. And then that's when it turns into town funds are needed to repair for drainage and for, sloping or for whatever the case is. So if you look at it as this preemptive, catch something at the beginning, have someone, working amicably. This isn't the third party review is not meant to be taken in a combative way. It's the protection of the town and the town's resources and the town's funds. Because I've worked in a municipality where they didn't get a third party review for a subdivision, and road wasn't built real great. And now those people who live in that road have, constant wet basements, flooding issues. I mean, who wants to have that? So all those types of things can be prevented with third party review. Huge fan, third party review.
Also mentioned that Steve did respond to the question about what RSA indicates that the onus is on the abutter or the applicant to provide the butter lists. So for those of you, you could look in the chat, and he did respond to that 676 :4 Roman numeral 1B is where that can be found. Somebody asked if the slides would be available. Yes, these slides are on the website now, and the recordings will be uploaded after the conference. I think there's some new questions that I have not seen yet.
Thank you, Steve. Oh, wait, did you find the third party review for a ZBA, just for curiosity?
I didn't see that one.
Oh, okay.
Yes, I'll tell you in a second. I'll look it up and text it out.
There's a question, how and when are planning board alternates used, and who decides?
That's could be found in your rules of procedure, and how each municipality, each board has different, guidelines for alternates. Alternates are utilized when a regular member is absent or has to recuse themselves. Some municipalities, I encourage, alternates to be involved in every case, sitting at the table. They can ask applicants questions. They can't make motions, and they can't be if they're not seated as a regular member. If I'm just an alternate on my planning board, I go to every meeting. I can ask the applicant questions. I can discuss with the board other questions, as long as, before they go into deliberations. If an alternate sits on a case because a member is going to be absent for one meeting, and that member comes back the next meeting, I guess that would be up to that municipality or how it is in your rules of procedure. Check with your municipal attorney. But I would be of the opinion that alternate should sit the whole way through that case. It's just fairness and transparency and continuity to have the same board members, acting on the application instead of board members switching in and out. I've seen some, municipalities, say that alternates can't even be in the room or they have to remove themselves from the table. It's up to each board, but that's where your rules of procedure and how that board, that municipality wants those alternates, how they want those alternates to be treated, that's spelled out in your rules of procedure.
So there was that follow-up question. Does the alternate have to finish out that item in subsequent meetings for the whole case? But just to clarify, you were saying it's your opinion that they should, but there's no rule that requires them to do that.
I don't know. Yes, it's my opinion that they should, just for continuity.
Yeah.
But we can maybe nudge the attorneys, Mr. Buckley and Mr. Frost, to see what the legal thing is about that, if there is any.
Yeah.
But that's just me as a planner saying that, I prefer it that way.
So the case law says that if a regular member is absent and an alternate sits for that person at a hearing, but the regular member is then available for the next maybe concluding meeting or hearing on the application, so long as the regular member who missed the meeting has an adequate foundational knowledge, they've reviewed the minutes of the meeting they missed, they reviewed the documents, maybe they watched the YouTube video, they could resume participation on that application. And the alternate would not be able to sit for that application, the regular member would. So it depends on the circumstances and also depends on whether the regular member really takes the time to know what information they missed.
Great. Thanks, Steve.
So I think we've addressed most of the questions. Ben shared that third-party review by both planning boards and ZBAs is governed by RSA 673-16. And then Steve posted RSA 676:5, Roman numeral 4, about the Board of Adjustment being able to impose fees to cover administration and cost of special investigative studies. So that's an RSA specific to their ability to collect, request fees to cover third-party review. So there's a lot of interesting stuff there in the chat, and I'm not sure, Stephanie, I will ask you, will the chat content be available when we upload the recordings?
I honestly don't know the answer to that.
Yeah, I don't think it will be. So
I don't think it is either in Teams.
I'm inclined to say copy and paste whatever you're seeing in the chat.
Yeah.
For this session.
Yeah.
But we are at 2:00, which I think we now have 15 minutes. We'll have a short 15-minute break. I want to thank everybody who participated in this. Ben, Steve, Stephanie, thank you for all your questions, and other members who chimed in with really valuable and good information to help answer questions. The last session will be the roundtable, where Stephanie, Steve, and Ben, I think we're going to stop the PowerPoint, and we're just going to have screen view, and we'll have some questions where you can write in questions, or we have some questions. I have questions from each session that I've copied and pasted, so we can continue to answer those questions if we don't get new questions.
Yeah, absolutely.
So at this point, I think we're going to take a little break, and we shall see you all at 2:15.
Okay, great. Thank you.
Thanks,
thank you, Ben and Steve. We'll see you in a few minutes.